They think that's a strategy, but in most cases, people are found guilty, and we try as many as we can, as fast as we can, and nobody tries more. But that's and what happens is they know that they can delay if a bond is not set, then their family is easier to come see them and can put money on their books, and they can get credit for time served here in the jail. And then they wait. And then if it's a state jail felony, they can spend their time and get released without ever going to prison, in many cases. But it's fine, 35 a year, at least. And that 35 to 40 a year. And that doesn't stop people from everybody wanting to put it on a trial docket. And all I can do is say, I'm not afraid to try cases, and we're going to try. That's what you have a right to do. We'll put these on the trial, and we'll just get you to trial as soon as we can. But we can only try one at a time, and it's stacked up like the ships offshore waiting to come into port. But that's all I can do. Just try. We can't figure out a way to try more than one at a time, of one different at a time, and I wish we could. So, Mr. Malbrough, it goes on the trial docket. I just wish things were different, but I don't know why. I can't make the deals. I'm not allowed to make deals, and deals need to be negotiated. If they're not accepted, then it defaults to a trial, and that's what we follow is the law. And I can't make the deals, and I trust professionals are going to do the best they can. So you're set for trying. So then we'll try one at a time. That's all we can do.
Thank you,
Sorry, Mr. Malbrough. Aaron Middleton.
He's also setting his case for trial.
See, that's
Yes, sir.
that's you, Derek Grant. Yeah. You're charged with the second-degree felony of assault on a peace officer. So here it is. Announcement.
Judge, the current offer is 5 years, and Mr. Francis does not want to take the 5 years.
Okay. All right. That's right.
Yes, sir.
Okay. Well, who wants 5 years? Does anybody? No. But what you're looking at, of course, is a second-degree felony. Here, you're looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000. You know that, right?
Yes, sir.
Looking at. And I'm not about to talk people into making deals, but I'm looking at there's also 3 misdemeanors, looks like he was charged with as well.
I don't know those, Judge. I'm
Okay.
not sure.
Assault, family violence, evading arrest, and resisting arrest. I don't see, it's not alleged any prior conviction, right?
He does have some out-of-state history from Louisiana, Judge. There is a burglary from 2013 and an aggravated battery from 2020.
Are those convictions? Felony convictions? We don't know yet, right?
I know the aggravated battery is, I need to double check with Louisiana on the burglary.
Okay. So he's been convicted of that?
The aggravated battery, yes, sir.
Okay. Well, if it's a felony, then you're not going to be even eligible for probation, if that's true. So the jury would be looking at 20 years. Okay. All right. That's your call. That's what we're going to do. Set for trial. All right. Then no deals on that one either. Okay. Kiana Kincaid. Hope everybody understands this court operates differently than other courts for some reason. I know the defendants in this court just want to all set their cases for trial, in spite of the fact most are convicted, and we try more cases than anybody. It's a mystery. I don't understand it. Okay, we have a different issue though in Kiana Kincaid in 23 CR 2013, a first amended motion to revoke probation. What are we doing on this?
Judge, the current offer is 5 years, and Ms. Kincaid does not want to take the 5 years.
All right, then when can we set this for a hearing? This week? Let's move her one way or the other. I'll have a hearing on Friday. Can y'all be ready?
I think I may be able to pull that off, Judge, with
Yeah.
I'm gonna sit second chair in this trial, and I think I can resolve that.
Okay. All right. then we'll have a hearing on it, and you're looking at up to 10 years in prison. You understand? You know that. He's talked to you about that. And it's my call. We'll see. Those are some serious issues here. The defendant's on probation for evading detention with a motor vehicle up to 10, sentenced to 10. Then we have abandoning or endangering a child, failing to report new arrest, failing to provide community service hours, failing at a location other than you, says his residence, but it's her, like at 11:51 on November 30th. That was when abandoning or endangering a child occurred. Failing to enter and successfully complete defensive driving, committing the offensive failure to ID on February 17th, failing to report for January, February, and March of 26, to the probation office, failing to remain in Jefferson County by being in Harris County without permission. 9 violations here, only takes 1. All right, that is all. Then let's get this on, we'll do this on Friday. There's no reason to spend time on this. Okay. And the state and the defendant, what are we here for now? There's an indictment pending on the state jail felony of criminal mischief. And what are you going to do today?
Your Honor, you set this for a hearing on the restitution issue on that, Your Honor. This case is pending. Mr. Borges is still not competent according to the doctors. However, there's restitution owed to the victim. You at a prior hearing stated that if the restitution was paid, we could get this going a little better. I was then informed that Mr. Borges has an individual who has the power of attorney over his finances, and I contacted the individual to make the payment. The payments have not been made, so we reset it for us to.
What is the payment amount?
The amount is I don't have an exact.
$2,726.25.
Very good. And so you want to have it here?
726.25.
Okay.
And you wanted to hear from the at one of the last hearings, you wanted to hear from the power of attorney and why the restitution.
All right.
So I was
Go ahead.
John Reese.
Somebody
Reese.
has
Reese.
Reese,
Reese,
come on.
Reese. Mr. Reese can't hear me.